Welcome back to The Explainer. So, let's just jump right in. In our last session, we figured out what evidence actually is and why courts absolutely need it to find facts and ensure fairness. Well, today, grab your notebooks because we're stepping away from the messy reality of a crime scene and we're stepping right into the strict academic rulebook of evidence law.
Now, to bridge the gap here, think back to that Kampala murder scenario we talked about. Remember? We had the bloody knife at the scene, fingerprints pulled off the handle, witnesses hearing a struggle, and of course, that threatening letter. But here's the real problem a judge faces. All that stuff exists out there in the real world. But how does the court actually decide which of those pieces it's going to look at? Like, how does it decide who's allowed to speak, what documents make the cut, and how much weight do they actually get? You see, judges don't just flip a coin. These decisions are governed by a highly organized, very strict body of rules.
And that exact body of rules is what we're unpacking today. Here's our roadmap. We'll cover the formal definition, the 4 fundamental questions every case asks, our primary statute here in Uganda, the main purposes behind all these rules, a really helpful metaphor to picture it all, and finally, how this plays out in civil versus criminal cases.
All right, I want you to take a second and write down this exact definition. I'm going to say it slowly because it's that important. Evidence law is the branch of law governing the means and methods by which facts are proved or disproved in legal proceedings. Got that? I'll say it one more time. It's the branch of law governing the means and methods by which facts are proved or disproved. This definition right here, this is the absolute foundation for everything else we're going to study. It's literally the framework that turns courtroom chaos into a structured legal argument.
So, to simplify this whole complex system, evidence law really just answers 4 distinct questions. Question 1, what can be presented? Look, not everything that's interesting or maybe even useful is actually allowed into a courtroom. The law meticulously dictates what types of material a court will officially receive and what gets tossed out immediately. Just because you have a piece of information doesn't automatically mean the judge gets to hear it.
Then we hit question 2, how must it be presented? This is all about the mechanics. Let's say a piece of evidence is allowed in. Well, there are highly specific rules about the format. How exactly must a witness speak on the stand? How do you physically hand a document over to the court? And, in our modern era, how do you authenticate a digital record so the court knows it hasn't been tampered with? You can't just toss a flash drive onto the judge's bench and expect them to look at it. There is a strict step-by-step method you have to follow.
Which brings us to question 3. Who can present it? This one determines who is legally competent to testify as a witness. On top of that, it lays out who can be literally forced, literally compelled against their will to testify. And conversely, who is entirely protected from taking the stand. Because frankly, not everyone who saw something is legally capable or required to talk about it in court.
And finally, question 4, what weight does it carry? Here's the thing. Getting your evidence admitted, that's really only half the battle. Once it's officially on the record, evidence law steps in again to guide the judge on exactly how much significance or weight to give it. Does this one single piece of evidence prove your entire case all by itself? Or does it legally need to be backed up, corroborated by other independent evidence before the court can actually act on it?
So you might be wondering, where do all these answers actually live? Well, in Uganda, the primary source of all these rules is found in one single place. Write this citation down very, very carefully. It is the Evidence Act Cap 8. I want to be crystal clear on this. It's not Cap 6, it is not Cap 7, it is Cap 8. This is the 2024 revised citation, and it's the absolutely correct one you need to use in all your exams and professional work. Literally every rule we cover, from relevancy to burdens of proof, traces straight back to this one statute and the Ugandan court cases that interpret it.
And it's absolutely fascinating to trace the historical journey of Cap 8. Just think about this for a second. Our modern statute is actually derived from the Indian Evidence Act of 1872. Let that sink in. The rules governing our digital evidence today have roots in a colonial law drafted over 150 years ago. That 1872 Act was basically a codification of English common law, tweaked for colonial territories. Through the East African legislative tradition in the early 1900s, Uganda inherited this framework. But it hasn't just sat there collecting dust. Over the decades, it's been molded, challenged, and developed through careful interpretation by Ugandan courts to actually fit our specific society. Which gets us to the 2024 revised citation of Cap 8 we use right now.
So why are we still reliant on a framework from 1872? Well, because these rules aren't just legal tripwires. They serve 4 incredibly deliberate purposes. First, finding the truth reliably.
We want courts dealing with tested facts, not rumors or speculation. Second, ensuring fairness. Both sides absolutely must have the chance to present and challenge evidence. Make sure you note down that this is actually a constitutional requirement under Article 28 of the 1995 Constitution of Uganda, which guarantees a fair hearing. Third, efficiency. Without rules cutting off irrelevant information, a single trial would literally never end. And fourth, protecting important interests. Sometimes finding the truth has to be balanced against protecting vital relationships, like lawyer-client privilege, even if that secret info could help solve the case.
To really grasp how this all fits together, let's look at how evidence law slots into the wider legal system. Think about procedural statutes, right? Like the Civil Procedure Act, Cap 282, or the Trial on Indictments Act, Cap 25, or the Magistrates Courts Act, Cap 19. Those statutes tell courts how to run a case from start to finish. So think of procedural law as the road you're driving on. Evidence law, on the other hand, that's the set of rules governing the vehicles allowed on that road, and exactly how those vehicles have to be driven. Procedure builds the courtroom. Evidence law controls the flow of information brought inside it.
Now, while the Evidence Act Cap 8 applies to both civil and criminal proceedings, as you can see here, it operates completely differently depending on where you are. In criminal proceedings, where someone's literal freedom or life is on the line, the rules are incredibly strict. The rights of the accused are heavily guarded, coerced information is strictly thrown out, and the burden of proof is incredibly high. Civil proceedings, though, much more flexible. The parties have way more control, some evidence that a criminal judge would instantly reject might actually be allowed, and the overall standard of proof is much lower. We're going to explore that vital distinction a lot more in later modules.
To wrap up our explainer today, I want to leave you with a really crucial discussion point to put in your notes, something to chew on before we meet again. Why do you think Uganda kept an Evidence Act based on a colonial Indian law from 1872? Like, what does that actually tell us about how law travels across borders and embeds itself? And most importantly, what modern realities in Ugandan society or technology or our modern courts today might a framework designed back in 1872 completely miss? Think about it. It's a huge question about the very nature of the rules we use to find the truth. All right, keep reviewing those notes, and I'll see you in the next one.